Welcome once again to Lehto's Law. Here's Steve Lehto.
There was a time when I did a bunch of videos about food and what was contained in the food and lawsuits filed by people who were aggrieved by said adulterated food and or non-adulterated food, that is food that didn't contain what it was supposed to. But it's been a while, so I got a bunch of people said, Steve, you got to talk about the mac and cheese lawsuit. The mac and cheese lawsuit. Kraft Heinz must face mac and cheese lawsuit. A judge has ruled. This is from Reuters. A federal judge said Kraft Heinz must face a proposed nationwide class action alleging that it defrauded consumers by claiming its Kraft macaroni and cheese contains no artificial preservatives. Mac and cheese is one of Kraft's best-known products. In a decision Wednesday, a U.S. district judge said that the consumers leading the lawsuit plausibly alleged that Kraft mac and cheese contains a synthetic form of citric acid differing from the natural variety, and also sodium phosphates. Now, the plaintiffs here are from 3 different states, Illinois, California, and New York. And I believe that they're trying to get this certified nationwide. So by picking plaintiffs from different states, that helps that. The Chicago-based judge said the plaintiffs specifically alleged that the ingredients functioned as preservatives, making Kraft Heinz's claim of no artificial flavors, preservatives, or dyes on labels false, and cited academic studies and U.S. Food and Drug Administration guidance to support their case. So these allegations are enough to withstand a motion to dismiss, she wrote. So generically speaking, someone files a lawsuit against you. You are a defendant. You can look at their lawsuit and go, oh, there's nothing here. Either the allegations, if true, wouldn't constitute a violation of the law for which you can be held accountable, or what they're alleging, fact-wise, simply can't be proven. And so apparently Kraft Heinz went into court and said what they're alleging wouldn't even be a case. And the court has said that no, there are these 2 things in there, and that appears to contradict the no artificial flavors, preservatives, or dyes. And so they've at least made enough to get past the motion to dismiss. This does not mean that they will win, and it does not mean it can't get thrown out later. But as of right now, they've cleared the first hurdle. So the judge agreed with Kraft Heinz that the plaintiffs lacked standing to demand new labels because they are now aware of the alleged deceptive practices and face no risk of future harm. So this is an interesting angle. The plaintiffs actually said that they want immediate action by the court to order Kraft Heinz to relabel the mac and cheese. And the interesting thing is the judge says, well, you guys know about this, right? And as of this moment, you're only speaking for yourselves. Do they need to change the labels to protect you from knowledge you already have? I mean, you know this. You don't need to be told this. So whether they need to do that somewhere down the road is another thing altogether. In seeking a dismissal, the company said there were no factual allegations that it used artificial preservatives in its iconic mac and cheese or that reasonable consumers would view its ingredients as artificial. Kraft Heinz and its lawyers did not immediately respond to requests for comment on Thursday. Lawyers for the plaintiffs did not immediately respond to similar requests. The plaintiffs are seeking damages for fraud, unjust enrichment, and violations of state consumer protection laws. Now, here's the question. If you talk about those things and understand that you are allowed to plead several theories and different causes of action can often work together, and so it very well could be that you could win on all 3 of those, for instance. However, let's talk fraud. Fraud is that somebody made a false statement regarding a transaction that you're entering into. You relied upon that false statement to your detriment, and they benefited. And you go, okay, that's pretty straightforward there, Steve. The allegation is that the fraudulent statement was no artificial flavors, preservatives, or dyes, right? Okay, let's assume that that's a false statement. A purchaser picked up the mac and cheese and goes, I would consider buying this, but I don't like preservatives or dyes or flavors that are artificial. Oh, this box contains none. I will therefore purchase it. And you purchased it and you consumed it, and that's now in the past, right? What is your harm? Were you harmed? Now, I know there are people out there who are going to say on principle, if I have something against ingesting something and someone tricks me into ingesting it, I've got a right to get upset by that. But how do you monetize that? What's it worth? $1? $1 million? $1 billion? Like, what's that worth? And so the fraud claim is interesting because one of those situations I've mentioned before, that to succeed in a lawsuit and come out ahead, you need to have both damages and liability. So with liability but no damages, imagine that you multiply them together. So liability but no damages equals zero. Big damages and no liability equals zero. You might go, Steve, what's that all about? Well, let's suppose that you got hurt really, really badly, but you didn't know who did it, or you couldn't prove who did it. Can't prove liability, but you got them damages. Yes, you do, but you need both. So the question is, if you were looking at this as a fraudulent situation where you were defrauded into purchasing a box of mac and cheese and you ate it or fed it to your kids, and you later found out that it contained artificial flavors, preservatives, or dyes, what are your damages? I'm just curious. Now, unjust enrichment is an interesting one. Unjust enrichment is an equitable theory where a court basically looks at a situation and goes, okay, somebody did something wrong, and allowing them to benefit from that would be not right. The court can step in and say, okay, it would be unjust to allow you to profit from that transaction. It would be unjust enrichment. Therefore, we're going to make you disgorge the money and give it back. And so the question then is, how much are they unjustly enriched for each box they sell? Because here's the thing, and I'm sure you know this already. If they get this certified as a class, they're going to say it contains, as a class, every single consumer who bought a box of this in the last 6 years, or whatever the statute of limitations might be. I'm just picking a random one. And so, obviously, from Kraft's viewpoint, that'd be a lot of boxes of mac and cheese, and it would add up pretty quickly. But to each person, let's suppose that you had kids who loved this stuff. How often do you eat it? Once a week? What's a box or two of that stuff cost? It's not that expensive. So the lawsuit is one of many challenging the accuracy or precision of food labels. In July of 2023, a Miami federal judge dismissed a lawsuit accusing Kraft Heinz of understating how long it took to prepare microwavable Velveeta macaroni and cheese. And I think I did a video on that one too. So Kraft Heinz is based in Chicago and Pittsburgh, and it's one of the big holdings of Berkshire Hathaway. The case is Hayes and others versus Kraft Heinz, and it's in the Northern District of Illinois, U.S. District Court, case number 23-16596. So, yeah, it got filed last year. But no artificial flavors, preservatives, or dyes. And it allegedly contains synthetic form of citric acid and also sodium phosphates. And again, I'm not a chemist. I have no idea. How artificial those are. But again, you look at this and go, okay, what are your damages? Because I can understand, we talked before about the woman who was eating at the restaurant affiliated with Disney, and she told the waiter, and also relying on the menu, that there were certain things that she could not eat, and it was a matter of life and death. And they said, oh yeah, we can take care of that for you. And they went and served her something that didn't conform to what she asked for, and she died. So it can be very serious about people ingesting the wrong things. But the question is, I'm not sure there's anything that rises to that level with those flavors, preservatives, or dyes. Now, I suspect that there could be someone out there who has got some allergy where a particular artificial flavor or a particular artificial preservative could affect them. And you're like, but Steve, that's it. Well, no, that's not it. Because if you're telling me there's one person out there or two people out there, that's hard to get a class action out of it. So obviously, if you came into the office of someone who does this kind of legal work and said, hey, my child has a severe allergy to a particular kind of artificial preservative, okay? And we discovered this early on. Now, doctors told us he or she cannot have, and yes, he or she, because the parent's not sure. After a while, speaking like an attorney, it's hard to undo that, and cannot eat food with this particular artificial preservative. We bought the Kraft macaroni and cheese because it says it doesn't contain any. Prepared it. We all ate it. Child got hospitalized. And you go, oh, okay. And what were they hospitalized for? My doctor will testify that it was an artificial preservative. No questions, no ifs, ands, or buts about it. Guaranteed. Well, you've got a decent case because you've got injuries and you've got liability and you've got people who are willing to testify to that. That's a decent case. But again, that would be one plaintiff, unless you could find a whole group of these people. And I don't know there's any allegation like that here. So I'm not saying that kind of action wouldn't be possible, but it appears here they're simply saying this food is mislabeled. And as a result of the mislabeling, people were tricked into buying it. Therefore, we think they should fix the label and either stop saying it or take those chemicals out. And I can follow the argument. Makes sense to me. But the question is, what's going to happen if this case gets resolved? Because we know that, generally speaking, when you see a class action lawsuit like this, what's going to happen is somewhere down the road, you might get a postcard. Actually, first, what's going to happen is they're going to say, hey, we have a tentative settlement worked out. If you've ever bought this particular product in the last 6 years, file a claim, go to this website and file a claim. Then you go to the website, you file a claim, and then you get a postcard that looks like junk mail. And it says in the postcard, here's what you do, what you don't do, what you could get, what you might not get, blah, 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 blah. And then another year down the road, you're going to either get something emailed to you or another postcard, which will turn out to be a check for 37 cents. And if you don't cash the check for 37 cents, then all the uncashed check money will get sent someplace, and the attorneys will get $19.4 million. As an example. So that's the story. But again, I've talked about this before. We talk about Pop-Tarts, right? Strawberry Pop-Tarts. And the question is, do they contain actual strawberries? And then, of course, there was somebody else who apparently filed a bunch of these. Any food stuff that said vanilla, even if it said vanilla flavored, if it didn't contain actual vanilla. And to me, that's a stretch to say that if you say something is flavored like something, that it still has to contain something, as opposed to just, I would think that vanilla flavored tastes like vanilla, but it doesn't have to contain vanilla. But that's what courts are for. They straighten these things out. So there you go. Thanks to everybody who sent it to me from Reuters. Kraft Heinz must face mac and cheese lawsuit. Judge rules. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Sarcasm is just another service I offer.